Wow, look at all those profiles jump up there. Okay, I'm here. That's an improvement over some nights. We just talked about that, Sarah. I don't have a deadline as such for the initial discussion post. As soon as possible. I mean, there's no reason not to do it right after class tonight or in the morning. You know, there's no reason to wait particularly. Just as long as you're not waiting until the last day, you know. Nobody has a chance to see what you write if you write it on the last day, except me. Do you need a deadline? I can give you one if you need one, but you might not like it. Okay. I'm missing two green checks, 3 green checks, 4 green checks. Where y'all been? We started 3 minutes ago. All right. We gotta move. Things to talk about, things to do. Okay, well, it is what it is. Okay, folks, we're going to talk about ethics and professional responsibility tonight. Your favorite subjects. You know, I used to think, and this is naivety at its worst, I suppose, I used to think that ethics were just doing the right thing. You know, as long as you were civil and moral and did the right thing, then that was pretty much it for ethics. And so there wasn't a lot to delve into. I've learned a lot more about ethics actually as a teacher than I did as an attorney. I never had any problems, any ethical problems. No one ever complained about me. And so I didn't really have to know anything about it, I guess, as a practicing attorney. And I think a lot of attorneys are kind of in the same way, that they know it's out there, they know it's something that they're supposed to abide by, but it's not something that's every day that they're concerned with, because day in and day out they're just doing the work, and ethics kind of takes care of itself. But it's not that simple. It's not that simple at all, and I've since learned that there are situations that can present a moral dilemma, if not an ethical dilemma, and that sometimes the moral choice may not be the ethical choice, because as professionals, we subscribe to a code of ethics. The code of professional responsibility, as it's called, and these codes take many faces in various states, but they're all actively policing the legal profession. And if attorneys are not living up to their responsibilities as legal professionals, then they can be disbarred. They can lose their law license, lose their ability to make a living as an attorney, or they may be suspended, where temporarily they're unable to practice. This happened on one of my favorite TV shows, The Good Wife. Some of you may watch that show. It's really, I like it a lot because the strategies are interesting and unique and thoughtful, I think. So anyway, I digress. But it may be more or less severe what can happen to the attorney as a result of an ethical violation. It may only be just a slap on the wrist. You did bad, do better. You know, it could be a public reprimand, could be a private reprimand. You made a mistake, it's going in your record, don't do it again. And so, you know, if we didn't know when we started out in the profession, we learn if we make mistakes. I know a few attorneys, very few attorneys actually, but that actually got disbarred. And I don't know what they did, and one of them I know what he did, but the other one I don't know. And so it's not something that happens a lot, I think, although when I pick up the bar journal in the back, it has all of the ethical rulings that have been made, and some of them you can't even tell who it is because it's a private reprimand. But if somebody is disbarred, well, that's there for everybody to see. Their names displayed, and anybody that was to dial them up at the state bar would find out they're no longer licensed to practice law. So attorneys do get disbarred. I know that. I haven't looked at the statistics. I don't know how many out of the total, or you know what percentage or anything like that. But I know that it does happen. And that's pretty serious. You know, when a person loses their livelihood, that's always serious. When a doctor loses their license to practice medicine, that's serious. They can't be rich anymore. Well, they can be rich if they're already rich, but they can't get richer. You know, attorneys are not, by and large, attorneys are not as rich as doctors, I don't think. But anyway, I digress again. Forgive me. Doesn't matter how rich they are. When you lose your ability to make a living, that's serious. And attorneys can lose their license for ethical violations that they do. They can lose their license for ethical violations that anybody that worked for them does. So it's up to them, it's up to the managing attorneys to manage actively, to supervise, and to make sure that all of their professional staff is abiding by the professional rules. That means the legal secretaries, the law clerks, and paralegals, associate attorneys, anyone that they are supervising, they're responsible for. And so since they're responsible for what you do, it's incumbent on us to make sure that you know what you should do or what you shouldn't do. And so that's what we're going to try to do tonight, to talk about some of the more serious things. It's not really possible to teach you everything there is to know about ethics and professional responsibility in 2 hours. That would be an impossibility. But we can hit on the highlights that will get you down the road. So we'll explain how the practice of law is regulated, analyze situation to determine several situations actually to determine whether it involves the unauthorized practice of the law. We'll define ethics, explain the difference between an attorney's rules of ethics and the paralegal's rules of ethics. Distinction without a difference in many regards. Explain the lawyer's ethical duty to supervise, which I kind of already did, but I'll touch on it again. Discuss the ethical obligations of competence. One of the things that attorneys sign on to in their Code of Professional Responsibility is an obligation to be competent. And I dare say when most attorneys get out of law school, it takes them a little while. They're a little less than that probably when they start out. because many of them don't even know where the courthouse is, much less how to file anything or get anything done there. So what I'm saying is you learn a lot of law in law school, but not necessarily practical things, the practice of law, and so that has to be learned. We'll explain the concept of confidentiality of client communications and attorney-client privilege, I hope, to your satisfaction. Discuss the concept of conflict of interest in the legal profession, important idea, and describe the duty of candor to the court and other counsel and the ethical duty of fairness. Remind me if I missed that, because I don't even think I've got a slide on it, but it is an important concept that we need to talk about. So how is the practice of law regulated? Well, lawyers have to have a license to practice law. That means that they have to go to law school, they have to get a degree, a Doctor of Jurisprudence, JD degree, and then they can sit for the bar examination. Bar examination is an intensive examination. Part of it is multi-state. It's the same thing all around the country, and part of it is essay. And they ask all these difficult questions for which there is no real answer, just to see how much law you know about a general subject. And so if you make a passing grade, then you get to be a lawyer. And I think I don't even know what the passing grade is now. I think it was 70, 72, 70, something like that when I took it. Maybe it was 74. But at any rate, they used to say anything over and above 70 was just wasted, because there's no, you don't get any points for making an A, you know. But nevertheless, it was an honor to have the top test paper at the bar examination. You usually got your picture made with somebody from the Supreme Court or something. That wasn't me. But I did all right. I made more than the minimum. So once you're notified, and it takes them an awfully long time to grade those things. So there's like 2 or 3 months that you're sitting around waiting for your results. Finally, you're informed you passed or you failed. You can take it again. I didn't have to take it again. I've known very good lawyers who had to take it again. And, you know, they were good lawyers, they just weren't good test takers. Anyway, you have to be sworn in, and you can either go down to Austin and be sworn in with a whole big group, or you can run down and find a judge. Any judge can swear you in. I had a judge on the Texas Court of Appeals swear me in. Very nice ceremony. And you get an affidavit or something to put on the back of your certificate, and then you can have it framed, put it on your wall. And Texas has a unified bar. Many states do. If you're a member of the Bar Association, State Bar of Texas, you're licensed to practice law in any of the courts of the state. And the state regulates attorneys in various ways through the Supreme Court and through the bar examination, which is accountable to the court. But the Supreme Court doesn't have time to do administrative stuff, you know, with the bar all the time. So it's the Bar Association that really regulates attorneys in Texas. And I think they do a good job of it. So that's how it's done in Texas. That's the way it's done in other states, that there will be somebody vested with authority to regulate attorneys in that state and to make regulations to adopt the professional code of responsibility and so forth. Initially, the code of professional responsibility was drafted by a bunch of attorneys who were affiliated with the American Bar Association, and so they came up with a model code of professional responsibility. and then that code was adopted in whole or in part by various states, and they made their own additions, subtractions to the model. So what you have is 50 different states that have different versions of the same thing. And to make it a little more complicated, they revised it several years later, and some states adopted the revision, some didn't. So there's considerable variation out there. Texas is pretty different in a number of respects from the model regulations. A couple of years ago, there was an effort to make Texas uniform with the model, and it was overwhelmingly rejected by the bar. I think the vote was 2-1, something like that. So we're not getting in line with the American Bar Association model anytime soon. There were some substantial differences of opinion, let's say. And anyway, that's where how attorneys are regulated. Now, what about paralegals? Well, paralegals, as far as I know, there is no direct regulation of paralegals in the sense that paralegals have to be licensed or they have to be certified. There are processes that have been developed in some states, like Florida, for instance, where there is a list that one can get on and have a designation after your name as being I forget what the designation is. It's not certified, but it's a Florida registered paralegal or something like that. And they probably sign on to some code of ethics in that process. And I suspect that most of the codes of ethics that would apply to paralegals, other than the Bar Association code of ethics, which we'll get to, most other types of codes of ethics would be voluntary in nature. That you don't have to you don't have to abide by those particular codes, but if you join those associations or you obtain those advanced certifications or so forth, then you sign on to the code of ethics that comes from those organizations. Like the paralegal associations. NALA has a model code, as does the NFPA, and there are others out there that are entirely voluntary. You can have them or not have them. There's been some talk about licensing of paralegals. There have even been a few bills introduced. There was one introduced in New York. There was one introduced in Florida. There was one introduced in California. As far as I know, none of them got out of committee. But legislatures have been talking about licensing paralegals, and one of the reasons for it is because there are some peoples in the profession that maybe shouldn't be in the profession, that are doing things that would otherwise be covered by the UPL statutes, which is the unauthorized practice of law. In other words, they're offering legal services directly to the public without being under the supervision of an attorney, which may violate UPL. Depends on what UPL says in a given state. At the same time, UPL is under pressure from the Federal Trade Commission, and bar associations are fighting Federal Trade Commission to maintain the UPL standards, to keep unauthorized, unethical, uneducated persons out of practicing law. That's the whole purpose of the UPL laws, to protect the public. The Federal Trade Commission takes the takes the tact that it's just a lawyer protection statute, and that you know, if we didn't have that, or if we could modify it, then we would have lower cost legal services, because we would have more people coming in and offering legal services to the public, even though some of those people may or may not be qualified to do the service that they're offering the public. So anyway, that war is going on at the same time, and we're in the middle of it. we're sitting here wondering how this is all going to come out. It's we think that the certification process is probably a good way to go. Licensing, you know, the argument for licensing is that it's like the nursing profession. Nurses help doctors, but nurses are separately licensed from the state. It's a little bit different the way legal services are rendered. What worries me a little bit is if paralegals were separately licensed and not really accountable to attorneys, or separately accountable to their own ethical associations, then an attorney, you would lose control, or you lose control of the process. What assurances could attorneys give clients that everything's going to be all right, you know, because you got different regulators and different. It seems to me that it could potentially put paralegals and attorneys at war with each other, particularly in things like professional malpractice, legal malpractice. Whose fault is it in a legal malpractice situation if somebody misstated a case, you know, when it's a collaborative effort to begin with? Who drafted that particular provision that resulted in the client being misled or given bad advice? Questions like that bother me, and I think that would. The other thing is, professional malpractice is a real concern for attorneys, and the cost of malpractice insurance has gone up and up and up. Because more lawyers are getting sued by other lawyers. Didn't used to happen. But as there are more and more lawyers looking for things to do, more and more lawyers are getting sued by other lawyers who are looking for things to do. And so it's a very real concern about malpractice insurance. Would paralegals have to have their own insurance coverage? Right now, if the lawyer has malpractice insurance, the paralegal is covered by the lawyer's malpractice insurance. So, you know, I think there'd be a lot of things to work out, iron out. I'm not saying it's not impossible, but it would really be a sea change in the way law is practiced if paralegals were separately licensed from lawyers. As it is, the responsibility for the paralegal's work rests with the attorney. And it's the attorney who pays the ultimate price of, you know, being potentially disbarred for ethical violations. So it's kind of a two-edged sword too, you know, licensing. If the state can give the authority, the state can take the authority. And if paralegals were separately licensed, they could lose their license, just like a lawyer could lose their license. So anyway, it's something that's getting talked about some. I don't know if it's really serious. If somebody's eventually going to pass one of these statutes, and then we'll see what happens. It hasn't gone anywhere so far, probably because there's a lot of lawyers and a lot of legislators. I mean, that's reality. There just are, because lawyers deal with the law all the time, and they make really good legislators, I should say. Okay, well, have I confused you enough? UPL laws, some of them expressly apply to paralegals, and others of them impliedly apply. They don't say paralegals are exempt, in other words. So if paralegals are not exempt, then my way of thinking, paralegals are covered because UPL laws, unauthorized practice of law, applies to the general public, that is, anyone who is not licensed to practice law. So even though paralegals can do a lot of things that attorneys do, there are certain things that they cannot do, and those are the things that are covered by the UPL statutes. And there's quite a bit of variation in the UPL statutes from state to state, so it's really impossible to lay out absolute standards and say you could never do this or never do that, because the law could change in another state, and then if it changed to allow you to do it, well, then you could do it, sure. So it's a moving target. It's a moving target. Well, some of you got here a few minutes later than others might have missed what I said about the supervision idea, that lawyers are the ones that are responsible for complying with the ethical codes. It's their tail on the line, and which means that they're responsible for themselves, and they're responsible for everybody in their office that reports to them, that works for them, and that the lawyer supervises. The lawyer has an obligation to supervise the staff and make sure that they understand the rules and that they're abiding by the rules. So in a very real sense, the same ethical obligations that apply to lawyers apply to paralegals, because you don't want to get your lawyer in hot water. And, you know, there's none of this right now. There's none of this, okay, paralegal, you go do this because I can't. That won't cut it. You know, a paralegal cannot do anything that a lawyer can't do. Give you a concrete example. If you were just a member of the public, not involved in the legal profession, there's a law out there called the Wiretapping Act, Wiretappers Act, something like that. It's a federal statute, and it says you cannot listen in on a wired or wireless conversation if you are not a party to that conversation. So you can't listen in on somebody else's call, nor can you record somebody else's call without their knowledge. And basically, there's a tariff that the telephone code tariffs also back that up. But there's an exception, and the exception is if you're a party to that conversation, you can record it without the other party's knowledge. Okay, that's if you're a member of the general public. Now, lawyers in their professional code of ethics, at least in Texas, have a provision that says you will not record anybody without their knowledge, period. It means on the telephone, it means in your office, it means, you know, person to person, period. You just will not do that. It is unethical to do that. Well, now you're a member of the public, but you go to work for that lawyer. Previously, it was illegal for you to record a conversation that you were a party to without that other person's knowledge. Now, it would be a violation of the lawyer's code of ethics for you to do that. And so now you can't. Does that make sense to you? Do you understand what I'm saying? That you're going to be subjected to the very same rules that attorneys are subjected to when you're working under the auspices of an attorney. And it's up to the attorney to make sure that you understand what you can and you can't do. That's one of the things you can't do. And so when you watch The Good Wife and you see Kalinda go out and do these incredible things that Kalinda does, some of which are probably illegal, you know, Kalinda is either the greatest investigator that ever lived and worked for a law firm, or she's the most unethical one. I think she's probably the most unethical one, or one of the most unethical ones. A lot of her methods are highly questionable, I would say. Well, let's look at a couple of situations and see if we can figure out whether it involves the unauthorized practice of law. Here we go. Paralegal says, hello, I'm Pat. I'm working on your case. Now, one of the things that UPL says is that you cannot represent yourself as an attorney. Is Pat holding himself out as a lawyer here? Derek says no. Elizabeth and Savannah say yes. Justina says no. Alex says no. Ashley, yes. Antoinette, no. Courtney, no. Sarah, yes. Well, we have an interesting difference of opinion here. Somebody want to speak on behalf of their opinion? Do we have somebody who can speak on behalf of?
Yeah, it's Daryl, the person. Can you hear me?
Go ahead, Daryl.
Okay, the person is not holding themselves out to be a lawyer. They never identified who they were and what capacity they were working on in the case. I mean, a secretary can be a person that's working on your case. You know, a private investigator could be in the office working on the case. The person, in order for them to put the impression that the person is a lawyer on that other person's mind, is by directly telling them that I'm a lawyer, or to give certain cues that would be more than just inferential. Then the person would say that you know, would be holding himself out as a lawyer.
Okay. All right. So we have that. Courtney, what were you going to say?
Can you hear me out?
Sure.
Okay, good. Well, like he was saying, it does leave it open for speculation. They're not specifying exactly in what manner they're working on the case. They're kind of leaving it open-ended, and it would be very easily misconstrued by a lot of people, I believe. Excuse me. It would be much better to like Leslie said, specify that I am the paralegal who is working on your case, or you know, making it very clear from the beginning. That's all I have for you.
Wouldn't be any question then, of course. Gina?
Well, yeah, according to what our text says, that the paralegal is supposed to tell the person that they are the paralegal, because if not, if you just leave it open at that, what if they start asking questions, the client start asking questions? The paralegal cannot answer those questions. Therefore, they have to represent themselves. Yes, hi, I'm Pat. I'm your paralegal. I will be assisting on the case. And if not, this person's probably going to think, okay, well, this is another attorney. I can ask these questions of this attorney.
Good point. Okay.
That's all I have to say.
All right. Thank you. Next. Was that Elizabeth?
Yes. So one of the things that we discussed in class on Monday was that you have to go off of what the standard knowledge is for who you're communicating with. So the phrase, hello, I'm working on your case, if that is the end of the communication, the end of the introduction, that's not providing any clarification. And if someone were to come up to me at least and say, I'm working on your case, there's a tendency to assume that very phrase entails that you are a lawyer because you're doing the most active work and you have the bulk responsibility of the work that is done. Now, if that wasn't the end of the introduction, then that would be fine, but it's better to always have a clear understanding of, with everyone you're communicating and dealing with, especially in the legal field, of who you are, what you're working on, and the specifics of it. So it's better to say, hello, I'm Pat. I'm working on your case as a paralegal under this attorney, just to make sure that it's clear and distinct from the beginning to the end of any interaction.
Okay, thanks. Olga?
I think that although clarity is very important, I don't think it would end on, hello, I'm Pat, I'm working on your case. If they would have said, hello, I'm Pat, I have taken over your case, then yes, we would have, more of an issue there. Now, hello, I'm Pat, I'm working on your case. I need you to submit this paperwork is still paralegal. If he says, well, what do you think will happen, then, you can put your foot down and say, I'm sorry, but, I am the paralegal on this case. I'm not allowed to give you, that information. So I think that there's going to be many, many, many people working on a case, depending on how large the case is. If it's a smaller law firm, normally the attorney, they know who their attorney is, so anybody else who comes in, they wouldn't automatically assume that they're the attorney. In a larger law firm, the cases are usually much larger, therefore there's so many people working on the case. Again, to assume something like that, it wouldn't be something that a lot of people would do in that particular scenario. And I think, as the conversation flows, you can actually find out, and that's in general in life. Nobody's gonna, hi, I'm Olga, I'm from this place, and I do this, and there's a certain way that you can kind of ease into it, and not just blurt everything out at the first moment.
Oh, okay. That wasn't me. Well, how hard would it be for clarity here to just say, hello, I'm Pat, I'm the paralegal, or I'm a paralegal working on your case. It wouldn't be that difficult to do, and there would be clarity. It only adds another word or two. And so there would be no question. And I think I come down, I've heard what everybody said, and maybe, you're probably not going to be brought up, put in cuffs and carried away for a criminal violation of UPL because you introduced yourself and didn't say I'm a paralegal. But I think it's a matter of good practice. It's a good idea to do that, just for clarity's sake. And get it, practice it so that when you, not that you're working on the case, but you could say I'm a paralegal at such and such law firm, rather than I work at such and such law firm. Well, the assumption might be you're an attorney. And attorneys can get in trouble at parties just simply by providing a little off-the-cuff legal advice. So the same thing can happen to paralegals. And if you're a paralegal and you put it out there to begin with that you're a paralegal, then people will understand that you can't practice law and because you're not licensed, so in a sense you're protecting yourself, keeping yourself from being asked those difficult to answer questions by your friends who think, oh well now, or if you just get straight between you and your friends right off the bat that you're not licensed to practice law, I can't answer legal questions, don't ask me. And that goes a long way. Courtney?
which is something that I've fallen into over the past few years. I've been helping out friends' children who have DUIs and things like that, and they didn't have the money to get it to go to a lawyer and actually have him handle the case. Now I'm no longer. When I started this class, I was like, wow, I got to stop doing all of that now. And I really had a lot of enjoyment out of it because we were real good at it. You know, the kids and I, we managed to get a lot of them out of hot water. But at any rate, now I can't do that. So that's all I got.
Okay. Well, it's that's the way we learn sometimes is by doing things that we're not supposed to do. Hopefully, we learn before we get in trouble doing them. And so that's why we're talking about it now. Here's another one. Paralegal says, client, you should file a lawsuit. Is the paralegal giving legal advice? I'm seeing a bunch of yeses going up. Anybody have a rule of thumb on what you can say or not say in terms of advice? Gina?
The advice what I would give is you should contact an attorney and leave it at that. That gets you out of trouble. That makes it clear that you can't help them or can't give any advice to them. That this is what they should do to get professional help.
Okay. Olga?
I think that if I can begin the statement with legally you should, then I probably shouldn't finish it.
That's probably a pretty good rule of thumb. What I hear most as a way of remembering what you can say and what you can't say, anything that you say that the person that you're saying it to could potentially change course, act on it, do something based upon what you are saying to them is advice, and you would not want to be doing that, because giving legal advice is the worst thing that you can do in terms of UPL. Derek?
Yeah, when you say giving legal advice, telling someone that they should file a lawsuit, that's not, to me, is not giving it legal advice. That's telling a person what course of action it should take. You're not sitting down with them and taking them through steps 1 through 20. And you should do this, you should do that, you should do this. You know, it's like if I saw somebody get beat up, I mean, by a friend of his or whatever, and for me to tell him, hey man, you should file a lawsuit against that person, that's not giving legal advice. I'm just telling the man what he need to do. You have a cause of action, you need to move on. Now,
I hear what you're saying.
He can go to a lawyer and proceed with the lawsuit.
Yeah, or he could go down and file pro se.
That's true.
And then what's he going to do?
Well, if he files pro se, then that's on him. But
yeah, and then the lawsuit gets thrown out because he misses the deadline, and then he comes back to you and he says, "Hey, why didn't you tell me to file a lawsuit?"
Well, I just told him to file a lawsuit. I ain't telling him how to do it or what he should do. That's like saying, hey man, if I was you, I'd go buy a Big Mac. They're real good this week. But let me ask you this.
Well, now that's saying it a little bit different. If I was you, I would do this, but that's less of advice and less legal advice and more just kind of, here's what I would do. But anyway, I hear where you're coming from, Derek, but I think it still probably is legal advice. Antoinette?
Hi, how are you?
I'm good. How are you?
This brings up a question that I haven't kind of been able to get a clear answer to. The whole goal of me getting my paralegal certificate is so that I can have my own business as a paralegal and not work for an attorney. So how would me working as a private paralegal, not with an attorney, if I'm filling out family law papers, unlawful detainers, wills and trusts, how do I avoid the UPL? I mean, I understand that the header of the paperwork, it would be improper because I'm not going to put my name as I'm representing the client. So where the attorney's name would be, it would be the client's name. But how do I avoid the line between giving legal advice when I'm filling out their forms?
Where are you, California? What state are you in?
California.
Okay. I don't know what the rules are in California, frankly, and so I can't tell you what you can or you can't do in California. I think there are some there are some ways where you can do things in California that you couldn't do in Texas, for example. But I'm just not familiar with them enough to be able to tell you how to do that. I don't think that you're completely out of business. I think that there is. I've seen some draft proposals, but I don't know, the status of those proposals that would allow paralegals would allow anybody really to provide different types of services, some legal services directly to the public. And I just don't know. I'm sorry, but you would need to find out specifically what the law is in California and what the limitations are in California. Okay. Sorry, I wish I knew everything. Sometimes I represent that I do, but Rita. I think we've got some other California people here. Maybe somebody's more familiar with it than I am. Go ahead, Farida.
Okay, can you hear me? Okay, can you hear me? Okay, great.
Yes.
I wanted to know if, as a paralegal, if somebody is asking me for an opinion, my friend, family, anybody actually, and if I start with saying, like you said, if I were you, I would do this, this, and this. Is that still committing UPL or no?
Well, the first thing you ought to say is if I were you, I would talk to an attorney. And then you're covered. I would definitely talk to an attorney is what I would do.
So not even if you say if I were you, it doesn't change.
This is the same. It's even more of a problem when you're an attorney and your parents or your sister or your children come to you and they want you to tell them, give them advice, and I've never thought that was a good idea because there's sort of a built-in conflict of interest in a family that what might be for their benefit might not be for my benefit or for my sister's benefit or my children's benefit, you know what I mean? So you can't be, it's difficult to be completely objective in that situation. And it's the same thing for anybody when you're talking to a friend. You want to be liked by your friends. It's very difficult to say hard things to friends. And sometimes if you were really giving the down and dirty advice, it would be harsh, and it could affect the relationship. So
yes.
I never think it's a good idea. I think it should be a pay pay-as-you-go kind of deal. You either pay for it or you go on your own. Everybody wants something for free, and a lot of times what you get is what you pay for.
Okay.
You ask for free advice, you get free advice, and it's worth exactly what you paid for.
Well, let me ask you this.
Which is nothing.
Let me ask you this: if you tell them you're not really sure, but you think this is the way, does that change the outcome?
Well, sure. I mean, of course, the less definite it is, the less it's advised. But is that better or is that worse? What if just because you say you're not sure, maybe you are sure?
Yeah, but
if you say you're not sure,
yeah, but that leaves them the other person to decide what they're gonna do with it.
Yeah. People can always remember conversations in different ways.
Okay, so just don't do it simply, right?
You never know. I mean, you never know.
Okay.
You just we all tend to remember what we want to remember, and I think it's worse in friends and relationships than it is with a professional relationship where you're objective, independent. You can really talk frankly about what the situation actually is and give some, objective advice as to what's advisable to do or not do.
Okay, thank you.
So I think that, anyway, I would just avoid it if I were you. I try to avoid it all the time. I try to avoid it too when students ask me legal questions about their own personal things. I charge $2.50 an hour, so you should know that right up front, in case you're thinking about asking. Okay, what is UPL? Well, here's another one. Paralegal says, sure, I'd be happy to complete those corporate bylaws for you as paralegal completing forms. Now, I know maybe in California you can do that. That's a possibility. But can't everywhere. And if somebody's asking the paralegal to just, I know you got some corporate bylaws over there, just fill them out, don't bother the attorney. They're looking to get something for free, right? Of course, they're trying to get something for free. And if the paralegal just fills them out and gives them to them, are they providing a legal service? Yes. I mean, that is a legal service. Are all bylaws the same? No, they're not. Bylaws, corporate bylaws, have to conform to state law. And every state has its own set of corporation law. So, what works in California might not work in Texas. What works in Delaware might not work in Idaho. You don't know. So they have to be tailored to the law of the state. And if they're not, then they're illegal. So if they're illegal, what good are they? Virginia?
Okay, so in other words, paralegals are not supposed to sign any legal documents. They can prepare them, but not to sign them. They have to be reviewed by an attorney, correct?
Well, it's not so much signing legal documents. It's if a client is asking you to prepare legal documents directly for them, don't bother the lawyer. You may well know exactly what they need, and it may be that the lawyer would just look at it and and not make any changes and just say, yeah, that's fine. That might be all that there would be to it. Or maybe that you had done this so many times and the lawyer knew that you knew exactly what you're doing, and so the lawyer would at some point tell you, hey, you don't even need to bother me with that. I'm fully all right with you doing this. I mean, it's the lawyer's responsibility. So if the lawyer's okay with it, I guess that's the risk that they're willing to take. But when if you're in Texas and you're filling out legal documents for a client, and there's no lawyer between you and the client, and I think that's probably unauthorized practice of law in Texas. That may not be the unauthorized practice of law in another state. These are uniquely state laws. They are criminal laws, by the way. And interestingly, New York recently made the unauthorized practice of law a felony. California did the same. So, you know, it is a serious thing. It's just a matter, I can't tell you exactly what you can do or you can't do in a particular state. You've got to determine that yourself. Maybe you need to talk to a lawyer to find out what you can do, what you can't do.
Okay, thank you.
I don't know, did I answer your question, Virginia?
Yes, you did, but what I'm saying is, like in the law firm that I work with, paralegals are not supposed to sign any legal documents. They can prepare them, have them ready for the attorney to review, but the signature is the attorney. Right.
Well, of course, that's what paralegals do, is prepare documents for the lawyer to look at and to make changes to, or to say they're okay and give them to the client, or give them back to you and tell you to give them to the client. That's fine. But the point is not doing it just because the client asked you to, you know, and don't tell the lawyer, because the lawyer's going to bill them for it, and they might be upset that they're not getting revenue from something that you're doing. So that's another aspect of it.
Thank you.
Derek? You bet.
Hi, I was just thinking, this just came to me when you were speaking in Virginia. Officers commit UPL every day. They're writing tickets that affect the legal right of somebody, and they're not lawyers.
What kind of officers are you?
On all of these traffic stops.
You're talking about officers of law, deputies?
Right, on these traffic stops. They're filling out legal forms that affect the legal rights of someone. That's UPL.
I think you'd be hard-pressed to say that they're giving advice or they're, you know.
No, I'm not saying that they're giving advice. Like what I'm saying is that when they pull you over and they pull out their little pad, they're filling out a form. That's an official legal form. They're not lawyers, and that information is being used in prosecution of someone that affects the legal right of someone.
Well, that's an interesting thought. Next time you get stopped, Derek, why don't you try that? See what kind of reaction you get. You see what I mean? It's an interesting proposition, but I don't think that's going to stop a cop from writing you a ticket. Do you?
No, I'm not saying it's going to stop it, but I was just thinking it fits within the category. The categories that are in Chapter 2.
Well, you know, you could say that about any law enforcement that ever writes a report, that ever does anything in law enforcement. I mean, that puts a parking ticket on your windshield. I just don't think, practically speaking, anybody's going to get excited about that. as being the unauthorized practice of law. I don't see that as the practice of law. It's not the practice of law to enforce laws. Really, it's criminal laws. It's criminal law enforcement. That's what it is. Which is a different. I think it's different. Farida, did you have another one, or? Did I just not take you off?
Yes, actually.
Okay.
Can you hear me?
Go ahead. Yes, go ahead.
You can hear me. Okay. Okay, I'm sorry. I'm going to just go back to Chapter 1. It says in Chapter 1 that paralegals may represent clients in some administrative cases, hearings. So why is that? And if there's some other hearings that paralegals are okay to represent the client?
There are some federal laws, United States government laws, that allow lay persons, that is, members of the general public, to represent individuals before certain agencies of the government. Like Social Security Administration says that you can have a lay representative in a Social Security disability hearing. So paralegals.
Yeah, but why is that?
Because it's federal law. I don't know why they adopted the federal law, but it's that's what it is. That's what allows it.
Okay. Thank you.
You bet. Courtney?
I was just replying and with her question about the layperson representing a person in the court of law. It was in California, you can represent someone in front of the Social Security Administration and in front of some of the federal agencies. So, at any rate, that's all I got.
Yeah. Well, you can do that in any state because it is a federal matter rather than a state matter. But it has to be an agency that particularly has allowed it. Okay. Well, here's what I would recommend to you now. You need to look at your own state law to find out for sure, but don't give legal advice. Just don't do it. Don't hold yourself out as a lawyer. Take steps to make sure that people know you're not a lawyer. Don't complete forms directly for people. Of course, you're going to draft forms that the attorney asks you to draft because you work for the attorney and you're going to do what the attorney wants you to do. But you don't want to be doing things on the side for clients, particularly on a revenue basis, where you're charging. That'll get you fired because you're being duplicitous. You're not being loyal to your employer. And don't represent clients. You can't represent clients in court. You can go with a lawyer, be part of the team, participate in a trial as a paralegal. Just don't stand up in front of the judge or the jury and make arguments. Now, there are agencies that allow you to do that, and you're not deprived of the ability to do that simply because you're a paralegal. So a lot of paralegals do that to help out and do a good job of it. Okay, well, it's about 8 o'clock, a little bit after 8 o'clock. This is the time we usually take a break, and we're about halfway through the material. So why don't we take a break now? Okay? Farida?
Uh-oh. Can you hear me?
Yes. Go ahead.
Oh, okay. Okay. My question is, once a lawyer loses their license, can they ever get it back, or that's it?
Well, it is permanent, but sometimes they might be able to get it back. It's hard to get it back. It's not impossible, but it's difficult.
Okay. Does it? Do they look when they decide if they're gonna give the license back? Is it about how big the offense was, or it
would be on a case-by-case kind of basis as to whether they feel like that this person could abide by the rules. I mean, when a person gets disbarred, it's because they broke some bad rules. The main reason for disbarment, as I understand it, is theft. So you know that's not somebody necessarily that should be practicing law.
Okay, I understand. But there is a chance of a lawyer getting their license back. It's not impossible, right?
There's always a chance, but it would have to show some, change of heart, some religious conversion, something.
Okay. Okay, thank you.
All right. Well, what's the difference between attorneys' rules of ethics and paralegals' rules of ethics? Well, other than what happened? I pushed. I don't know what's.
You're taking us on a web tour, Larry.
Okay, doggone it. That is irritating as the dickens. I'm doing the same thing. Somehow or another, a video has crept into this. Okay. Maybe I'm okay now. That was weird. I thought I hit the wrong button, but I didn't hit a wrong button. I hit the right button, and it still did it. All right. Well, attorneys have one set of rules. Whatever the state's model rules of professional conduct, as modified by the state, that's what the rules are in that state. They're adopted by the Supreme Court of each state, and attorneys have to follow those rules. They apply to all law firm employees. So in that sense, your rules are the attorney's rules. It's just that if you don't follow those rules, it's the attorney's mistake, or the attorney that has to pay the price for it. You might get fired or disciplined, but it's the attorney that's ultimately responsible for complying with those rules. There are lots of guidelines for paralegals, but not one mandatory set of rules. The ABA has some guidelines on the use of paralegals in the practice of law. These various ethical codes of the paralegal associations, which are really more, again, model rules. But if you join those paralegal associations, then you subject yourself to those rules. Some states have a separate set of rules. For example, in Texas, the paralegal division of the State Bar of Texas has a set of ethical rules, and if you join the paralegal division of the State Bar of Texas, then you make yourself subject to those rules. And then the national paralegal associations, NALA and NFPA, they both have ethical guidelines and rules that apply to their members. But those are voluntary associations. You don't have to join those associations, But if you do, then you become subject to the rules. Well, fortunately, most of these rules are consistent with each other, and you don't have a lot of conflict between the rules, so that's good. But as far as whatever the lawyer's rules are in a given state, you're on your own to find out exactly what those are, and also to find out what the UPL laws are in your state, which is two different things. I noticed last time, maybe I didn't make a good enough distinction when I was teaching the class last time, but a lot of students I noticed in discussion questions and so forth were referring to ethical violations as a violation of UPL. It's two different things. UPL are the criminal laws that apply to persons who are not licensed to practice law, and say that you cannot practice law without a license. Okay, so the issue in UPL is what constitutes the practice of law, and that's it. It's usually a matter of what does the statute say, how has it been defined or interpreted by the courts of the state, and so you could have different interpretations even of the same statute. But ethical violations emanate from the model laws that were promulgated initially by the ABA, the rules of professional responsibility, and that have been adopted by the state legislatures. Those are the ethical rules that apply to attorneys. And so when we talk about confidentiality or the attorney-client privilege or those things and those kinds of violations, they're ethical violations of the codes of professional responsibility, not UPL. UPL is the unauthorized practice of law, something different. But you as paralegals have to be aware of both because you don't want to run afoul of either. You want to comply with the ethical obligations of attorneys so they don't get in hot water and at the same time comply with the UPL laws so you don't get in hot water for practicing law without a license. I hope I explained that adequately. If you have a question about it, I completely understand because it is a little confusing. But being able to differentiate between UPL, the unauthorized practice of law, and ethical violations, two different things. Ethical violations would be those ethical obligations that you take on by virtue of being a paralegal and working for an attorney. And that's different from UPL. The lawyer does have an ethical duty to supervise everyone in the law office, the administrative assistants, the secretaries, the associates, paralegals, everybody that they supervise. It's their obligation to make sure that you're in compliance with the ethical codes. And if you're not, well, it's their problem, their problem. So a lot of these things that come up as far as ethics, you can take to the supervising attorney and say, here's what's happened, here's the situation, what do you think should be done? Because ultimately it's their responsibility, and always err on the side of letting them fulfill their responsibility. I mean, not everything is clear cut, you know, as to what you should do. And so you shouldn't be in a situation where you don't know what to do and you have to decide. You know, if you don't know what to do, you should be able to ask somebody, what should I do? And that somebody should be a supervising attorney. Okay, the ethical duty of or obligation of competence. A lawyer in their professional code says that they are to be competent, skillful, that they have the skills of an attorney, which means if they're a litigator, that they're familiar with the rules of evidence and the rules of civil procedure, and that they're thorough, that they are not careless, but that they make thorough preparation for everything that they do. Preparation for depositions, preparation for hearings, preparation for trials, and that they have an adequate legal knowledge. That's an ongoing project. Nobody knows all the law. I've met some really smart lawyers. I've met some lawyers that have photographic memories. I don't have a photographic memory by any means, and most lawyers do not. So, you know, we learn a lot of law in law school, but just like any education, if you don't use it day in and day out, you don't remember it. And so it's like when I was getting ready to teach the Certified Paralegal, Certified Legal Assistant Review course, I had a big thick book. Well, I'll show it to you. Hang on a second. This was the initial review manual that I had to get familiar with in order to teach the review course for the NALA CLA CP certification program. And there are nearly 1,000 pages in this book. There's a lot of law in there. And as Aida and I were reviewing it, we both remarked to each other that, you know, this is like studying for a bar exam. And some of these examinations that paralegals can take when you get through are very, very thorough and test you over a lot of legal knowledge. And if you do well on that exam and get that certification, you're competent. I mean, you know what you need to know to be a paralegal and to be of real service to an attorney. So, but you know, we were looking at things that we hadn't thought about in 30 years, at least in my case, 30 years. So you have to stay up in your field, whatever your field is. And, you know, if you have a broad field, that's very difficult to do. If you happen to work for a generalist who does a lot of different things in a lot of different fields, it's difficult just to stay up to date with the cases in a particular field, much less several different fields of law. It's very, very difficult to do that. So it takes a lot of review, constant going to CLE programs, continuing legal education programs, and reading the case notes of recent cases from the courts of appeals, from the Supreme Court, not only the Texas Supreme Court, but the United States Supreme Court in many areas of law. So it's a daily effort to stay current, to stay competent. And you know, hopefully you will have a fairly narrow focus and be able to concentrate on one field of law. That's the best way to stay competent. If you're spread too thin, trying to do too many different things, it's almost impossible to be competent or to remain competent in all those different fields. So, you know, you've heard that expression, a jack of all trades, a master of none. Well, you can double down on that in the legal profession because there's a lot that goes into being competent. Well, I go into this simply to say that the same ethical obligation that applies to attorneys applies to paralegals. And so you, in fulfilling your ethical obligations to the client, the ultimate client, and to your boss, the attorney that you're going to be working for in some capacity, either as an employee or as an independent contractor, you have an obligation to be competent. And Hello. Fell into a black hole. I don't know what happened. Alexis? I am back. That has happened before, and I don't know exactly what's going on, but it just says that the connection is lost, and usually the screen goes black, and then it comes right back. Tonight, it wasn't coming back, so I don't know what happened. Maybe it's a sunburst interfering with the satellite connection or something. Sunspots. Yeah, it could be something like that. Maybe. I don't know. We have satellite connection for our TV. I don't know about if the telephone comes through satellite or if it's coming through a wire. It's AT&T. Solar flare. Anyway, sorry about that. I don't know if I finished my point or not. I was trying to make the point that this obligation applies not only to attorneys, but it applies to paralegals as well, because you're working for the attorney, and so you owe an obligation of confidence to your client. Now, what you're doing here in class is going to help you to be competent when down the line, when you graduate, when you get your certificate, when you take your certification exam, whatever it is that you do to prepare yourself, it's going to help fulfill this obligation of competence. Confidentiality of client communications and attorney-client privilege, related to each other, but different concepts. Everybody's heard of attorney-client privilege. Not everybody's heard of the ethical obligation of confidentiality. But in the legal profession, lawyers and paralegals are obliged ethically to keep all information regarding the client as confidential. And basically the obligation says just that, information. It's not strictly applying to communications, but certainly communications between the client and the firm, either attorneys or paralegals, also need to be kept secret. But any information regarding the client, including any information that you learn from another source, not necessarily from the client, but information about the client that you may come into contact to in any way, should remain confidential. Well, what does that mean? Does that mean you can't talk to your wife or your husband about what's going on at work? Yeah, that's pretty much what it means. Now, I usually give a lecture that what happens between husbands and wives is none of my business, and that's true. It is none of my business, and it's nobody's business. But and there are different kinds of relationships. You got to understand that there are relationships that are absolutely rooted in confidence and confidentiality, and so that's a key thing in their marriage. And so everything that they say to each other is between them and nobody else, and both of them are comfortable with that. That kind of relationship, maybe you can talk a little bit, but not much, even in that kind of relationship, because you never know how something can slip into a conversation accidentally that could be important, and that the spouse would not realize that the importance of it. That's the other thing, that you, in talking to your spouse, would understand the importance of it. But your spouse might just be information to the spouse, not, that's what's going on with Ronnie, He's got this big case he's all upset about, so it could easily just come into a casual conversation. Somebody else could find out about it. Somebody who needed to know or wanted to know about it could find out about it. Newspapers could find out about it. Investigators for the other side could find out about it. I mean, these things can get out, and there's some information that you just do not want out, and that's any information about a client. Even the fact that the client is a client. And not always does a firm acknowledge that. Here's the deal. People come to lawyers because they have problems. Nobody goes to a lawyer because they're happy. They all go to lawyers because they've got a problem. They may or may not want anybody else to know that they've got a problem, particularly if they're a celebrity. You know, I mean, you would anticipate that a celebrity would have lawyers, I guess, to talk about contracts and so forth. And so there might not be any harm in it, but, you know, it could be a domestic abuse thing, too. And if that's the case, well, sure, heck, they don't want anybody to know about it. So anyway, the broad ethical obligation is to keep everything concerning the client confidential. And if you say nothing about the client, you're fulfilling that obligation. That really should be your goal, just to limit your conversations to something other than specifics about what's going on at the office.
Quick question. Is privileged and confidential the same thing?
No, it's not. The attorney-client privilege is something. You can think of it as a subset of confidentiality. It flows from the obligation of confidentiality, and the purpose of the privilege, attorney-client privilege, is so that a client can speak confidently, can give full information to the attorney, to the paralegals, to the legal team about their situation, so that they can get competent legal advice. If you don't know all of the factors, if you don't have all the pieces of the puzzle, then you cannot give a complete answer to the problem. And so the attorney-client privilege is it's actually a rule of evidence. And the rule is that any information divulged by the client to the attorney, or the paralegal for that matter, is to be privileged if the purpose of the communication was to obtain legal advice. Well, that's why people go to lawyers. So if they're there talking to a lawyer, they're there to get legal advice. And any communication it's really communication from the client to the attorney. Now, the thing about the privilege is that the privilege belongs to the client. And so the rule of evidence is that if a matter is within the attorney-client privilege, then an attorney or a paralegal who has that information cannot be compelled to divulge it. They cannot be compelled to testify or reveal information within the attorney-client privilege. So that's different from the obligation of confidentiality. Obligation of confidentiality is not absolute in the sense that if an outside party could show a need for information in the hands of an attorney that is confidential but not privileged, then they could be compelled to testify about that confidential information if the party could show a need and no other means of obtaining that information. So if for instance, you had, as a result of an investigation, let's say, information that would suggest criminal activity of someone. And this is not information that was given to you by the client, but information that was independently obtained. It's confidential. You shouldn't be revealing it. But with a court order, you would have to reveal it. Whereas information within the attorney-client privilege, even in the face of a court order, you cannot be compelled to testify as to that information. Confidentiality can be waived by a client. Privilege can be waived by a client, but apart from waiver by the client, attorneys and paralegals are bound by both obligations. And one is not even theirs to divulge. The attorney-client privileged information, the information that the client has given the attorney to seek legal advice, that is absolutely privileged, and that belongs to the client. If the client says, I'll never allow that to be divulged, attorney has no choice in the matter. There have been some spectacular situations where I can think of one in particular, and we'll come back to this at the end of this course. But it has to do with the situation where the attorneys knew from their client that their client had committed a crime and that someone else was in prison for the crime. But they could not reveal it because it was information that was given to them by the client, subject to the attorney-client privilege. And so years went by, and they pleaded with the guy to, let them some way or another reveal this because an innocent man was rotting away in prison. And the client would not give in, and they could not conceive of any way that they could divulge it without incriminating their client, and they couldn't do that. So there's a situation where morality would say, well, sure, they should have revealed it. That would have been the right thing to do, but it would have been the wrong thing ethically as far as their professional responsibility. So it really is, morality and ethics are not exactly the same. Sometimes the ethical obligation trumps the moral obligation.
It's really interesting because 90% of the people that come into the firm and ask for legal advice lie, and lie constantly, and they don't stop lying. And it's like, oh no, I don't have a bank account here. What are you talking about? But is it
yeah, that's
okay
true.
if we say, listen, did you know that if you actually are honest with us, we can actually protect you from things, and if you're not, and explain to them the difference? Or is that too much information from our part?
Well, I don't think you can counsel, if I understand what you're saying, I don't think you can counsel someone how they can avoid complying with the law, or how they can commit a crime. Am I understanding you correctly?
Yes and no. Logically, yes, that's basically what they would be thinking at that point. But me more on a civil, term where they give us all of the information. If we have the information, we can consider it privileged. So unless the other party actually requests it or, has certain knowledge of it, we do not have to, give any extra information. Do you know what I mean? We can.
Well, right, and if it's actually information that was provided subject to the attorney-client privilege, you cannot. Even if it's requested, from the other side. You know, you cannot turn it over.
Cool. Thank you.
But so anyway, privileges and evidentiary rule protects communications from being disclosed at trial. That's the attorney-client privilege, and this is information given to an attorney, given to a paralegal in order to obtain legal advice regarding the problem. Conflict of interest is a unique concept in the legal profession. The interest of one client is directly adverse to the interests of another client sometimes. You know, an attorney is what we call in law an agent. And the client is what we call in law a principal. The principal-agent relationship is such that the principal is in control of the relationship in many respects. The principal decides what the agent is to do. So the agent, the attorney, can give advice to the client as to what they think the client should do, but ultimately it's the client's decision as to what they do. Attorneys who represent the public tend to have more than one client. At least successful attorneys have more than one client. When those clients have interests, when those principals have interests that conflict with one another, in other words, they have a dispute. Let's say client A has a dispute with client B. Well, now the attorney is caught in the middle. They have ethical obligations that flow to both clients, and they have to do whatever the client tells them to do. Well, you cannot serve both of those masters, both of those principal clients who have different points of view that conflict with one another. In other words, you can't be on both sides of a lawsuit or a dispute and represent both parties to that dispute. That would be a conflict of interest. It presents a conflict to the attorney. The conflict is actually between the clients, but it presents a conflict of interest to the attorney because they cannot ethically represent both of them and represent both of them diligently, represent both of them to the fullest extent of the law, because what is advantageous to one would be disadvantageous to the other. Can't do that. So when there is a direct adverse interest of another client, then you've got a conflict of interest. Husband and wife in a divorce, certainly. Can't represent them both. Patient and a doctor in a medical malpractice case, no way. The patient's going to sue the doctor's going to defend against the lawsuit. You can't represent them both. A discharged employee, an employer in a wrongful discharge case, no way to do it. That's an irreconcilable conflict. They're just on polar opposite sides of the case, and you can't represent both of them. Now, sometimes the conflict is not so direct. It may be a potential conflict of interest, but not yet an actual conflict of interest, where maybe the one that comes to mind a lot of times is the driver and the passenger in an automobile or have a collision with another driver of another automobile. Well, initially the driver and the passenger go to the same lawyer and want that lawyer to represent them suing the other driver. And you would think, well, their interests are parallel. They're not in conflict. That the passenger and the driver of the same vehicle both want to sue the socks off of the guy that hit them, that they claim it's his fault. Well, now if the other driver claims that, let's call that driver B. If driver B claims that driver A is partially negligent for the accident, then that's going to put a conflict between driver A and passenger A. because that could reduce passenger A's recovery if driver A has any part of the negligence. So now, in order for passenger A to be sure that they're going to fully recover, they would have to sue not only driver B, but also driver A to make sure that they're going to get 100% recovery. Either that or they're going to have to potentially give up part of their recovery simply because the car they were riding in was partially negligent. And they're probably not willing to do that. So, and the attorney could not resolve that dispute between them, you know, because what was good for one would be bad for the other. It might not ever come about, you know, it might not ever be a problem. And so possibly they could go down that road. But as soon as it became a problem, then they would have to divorce themselves from the case. Well, attorneys have to be on the lookout all the time for these conflicts of interest, and that's why all law firms have conflicts checking mechanisms to make sure when they have a new client that this new client doesn't present a conflict of interest with existing clients or conflicts of interest with former clients that they formally represented. Say maybe the firm represented a husband in a business matter, and then later on the wife came in and wanted the firm to sue the husband for divorce. And so the question would be, well, now any information that they had from the previous representation of the husband, would that present a conflict in representing the wife? And even if they decided that it probably didn't, the husband probably would think that it did. And so there's likely to be a dispute about it. They might win or they might not win, but so situations can come up in a lot of different ways, and law firms have to be constantly aware of what's going on with their clients and try to protect themselves from conflicts of interest, because it is a problem. Describe the duty of candor. Lawyers and paralegals should always be truthful to opposing counsel, to courts, to people that work in the courts. Lawyers are, what's the term, an officer of the court. In addition to being a representative, of being an advocate in court, they also represent the legal system. And in order for the legal system to function, they have to be forthright with each other and with the court. So lawyers should not be engaging in chicanery, trickery, nor should their staff be doing the same thing. It's not to say that it doesn't happen, but the ethical obligations would be such that would say you have a duty to the system not to do that, and to be fair. So the things like I was telling you about making a secret recording, the thing to do would be to forthright and say, I would like to record this statement. Do you have any objection to my doing so? And, you know, and then when the party said, no, I have no objection, would you mind repeating that on tape? So I'm going to start the recording. I'm going to ask you the question again and ask you to repeat what you just told me. And so I'm recording this conversation. Do you have any objection to being recorded? No, I do not. Good. Let's go. So you've got it recorded, and now you're ready to go. So that's being forthright and honest, not engaging in skullduggery, spying to try to find out what you want to find out. Doesn't mean you can't have a private investigator on occasion. It just means that in dealing with opposing counsel dealing with the court, you have to keep in mind that the objective is to do justice, and that's the ultimate goal. Okay, well, so there's ethics, there's mutual respect, honesty, fairness, candor. All of that is involved in being a professional, and it may sound like a bunch of bunk, but it's not. I mean, people take this seriously, and you should take it seriously because it's important. It's important to your career, it's important to your attorney's career, and it's important to the system. So, you know, I'm looking. I see exactly what happened now. I did have a web tour down here. Well, sorry, we didn't get there. My bad. Or maybe you did get some of it. I don't know.